The morning after Dorothy's funeral, her son Michael stood inside a Chase branch on Washington Street in Naperville, Illinois. He held a certified death certificate in one hand and a notarized last will and testament in the other. His mother had done everything right. She hired an attorney. She signed the will in front of witnesses. She stored the document in a fireproof box under her bed. She called Michael and told him she had taken care of everything. She had $350,000 sitting in that branch. Michael needed $11,500 to pay the funeral director. He sat across from the branch manager, slid the documents across the desk and waited. The manager looked at his screen. He looked at the will. He slid the documents back across the desk and explained, in the same tone you use to read a lunch menu, that the bank had no legal authority to release a single dollar. Dorothy never filed a payable-on-death form. Her account carried only her name. Because the balance exceeded Illinois' small estate threshold of $100,000, the entire $350,000 now belonged to the probate court. The will meant nothing. The branch manager was not being cruel. He was following federal banking code to the letter. Michael walked out of that bank with nothing. That story is not a tragedy from 1970. It happened last year. It is happening somewhere in America right now, today, while you watch this video. And the reason it keeps happening is that the banking system has constructed a wall between your family and your money. And almost nobody tells you the wall exists until your family is already standing on the wrong side of it. I want to spend the next few minutes walking you through exactly how this wall was built, exactly where the hidden door is, and exactly what you have to do this week to make sure your family never ends up in Michael's position. Let us start in 1969. Because that is where this problem has its roots. On August 15th of that year, the National Conference of Commissioners on Uniform State Laws finalized a legal framework called the Uniform Probate Code. Article 6 of that code contains a provision that the average American has never read and almost certainly does not understand. The provision governs what happens to a bank account when the account holder dies. The answer is simple and brutal. If you die without a named beneficiary on the account itself, the money belongs to your estate. Your estate is not your family. Your estate is a separate legal entity with no hands, no voice, and no ability to act without a judge granting a living person the right to speak on its behalf. That process is called probate, and it is one of the most expensive, time-consuming, and emotionally exhausting things a grieving family can be forced to endure. The system was designed in a different world. In the late 1960s, the average senior citizen held a few $100s in a paper passbook savings account. The probate courts were built to handle small, predictable transfers over many months. The court took its time because time costs very little, and the amounts involved were modest. Then everything changed. The economy moved forward. Real estate prices exploded. A house bought in 1988 for $142,000 sells for $415,000 today. Seniors are now sitting on balances in the hundreds of thousands of dollars inside standard checking and savings accounts. Federal regulations shifted with the Germain Depository Institutions Act of 1982, which changed how banks handle asset transfers at the institutional level. But the state probate laws barely moved. The small estate affidavit threshold in Illinois still sits at $100,000. In many states across the country, that number has not been meaningfully adjusted in decades. The result is a system perfectly calibrated to trap middle-class families. The thresholds are low enough to catch ordinary savings. The fees are high enough to cause real damage. And almost nobody explains any of this until the vault is already locked. Let us go back to Dorothy because her story is worth understanding in full detail because her story is your story if you do not act. Dorothy turned 71 last October. She spent her working life teaching 3rd grade in Naperville. Her husband Eugene worked for the county. They were careful people, disciplined people. They bought their house on Maple Avenue in 1988 and paid it off over decades. When Eugene died of pancreatic cancer in 2022, the medical bills were significant, but the house was free and clear. 2 years later, the stairs became too much for Dorothy's knees and she sold the house for $415,000. She moved into a ground floor apartment near the library and deposited $350,000 of the proceeds into a standard savings account at the Chase branch on Washington Street. Dorothy was not reckless. She was not careless. She hired a local attorney and paid him $800 to draft a proper last will and testament. The document specifically named her son Michael in Seattle and her daughter Sarah in Austin as equal beneficiaries of everything she owned, including the Chase account. She signed the will in front of 2 witnesses and a notary public. She stored it in a steel lockbox under her bed. She called Michael and said, "I've taken care of everything." That call was the last financial conversation they ever had. On a Tuesday morning in November, Dorothy suffered a massive stroke in her kitchen and died before the ambulance reached the hospital. Michael and Sarah flew into O'Hare the next day on credit cards. They met with the funeral director. They received an invoice for $11,500 and assumed they would settle it within the week, using money from their mother's account. That assumption was wrong. The branch manager on Washington Street was not the villain. He was a man following federal banking code. Under the Uniform Multiple Person Accounts Act, and specifically under Section 6212 of the Uniform Probate Code, a bank account is a contract between the depositor and the institution. When the depositor dies, the contract terminates. The money does not automatically pass to anyone. It becomes property of the estate. The will is not a contract. The will is a letter of instruction addressed to a probate judge. It carries legal weight inside a courthouse. It carries no weight at a teller window. The teller window answers to a completely different set of laws. Here is the part that most people find genuinely shocking when they hear it for the first time. A last will and testament does not bypass probate. It guarantees probate. When you die with a will, your family must take that document to the county courthouse and petition a judge to validate it. The judge must confirm the will is authentic, that it was signed properly, that no one is contesting it, and that the person you named to manage your estate, called the executor, is legally qualified to act. Until the judge issues what is called letters of office or letters testamentary, nobody can touch anything. The bank is required by law to freeze the account the moment they learn of your death. Now let us count what this actually cost Dorothy's family. Michael retained a probate attorney in DuPage County. Under Illinois law, 755 ILCS 518-3, the estate was required to publish a notice to unknown creditors in a local newspaper for 3 consecutive weeks. The publication fee in the Daily Herald came to $250. Michael was required to post a fiduciary bond to protect the estate from potential mismanagement, and the premium on that bond cost $1,000. The initial filing fee for the petition for letters of office was $389. And then there were the attorney fees. Probate attorneys commonly charge a percentage of the gross estate. On an estate of this size, the standard fee sat at approximately 3%. 3% of $350,000 is $10,500. Add those numbers together. Filing fee, publication, bond, attorney. The total damage exceeds $12,000. Beyond the money, the mandatory waiting period in Illinois, designed to give unknown creditors time to surface, stretched the process to 14 months. For 14 months, Michael and Sarah could not access a single dollar of their mother's savings. They paid the funeral director on a credit card charging 22% interest. They took time off work. They filed paperwork. They appeared in court. They waited. They grieved their mother inside a system that treated their loss as a case number on a docket. Now I want to show you the other version of that same morning. I want to change exactly one thing about Dorothy's story and watch how the entire outcome shifts. When Dorothy sat at the desk to open her Chase savings account, the teller handed her a standard signature card. In this version of the story, Dorothy asks one question. She says, "Do you have a payable-on-death beneficiary form?" The teller prints a single sheet of paper. Dorothy writes Michael's full legal name, his date of birth, and his social security number. She writes Sarah's full legal name, her date of birth, and her social security number. She assigns each of them 50%. She signs the bottom of the form. The teller processes it. The transaction takes 7 additional minutes. Dorothy still suffers the stroke. She still dies on that Tuesday morning in November. Michael and Sarah still fly into O'Hare. They still walk into the branch on Washington Street. Michael hands the teller the exact same certified death certificate. The teller looks at the screen. The teller sees the payable-on-death designation. Under FDIC regulations, specifically 12 CFR Part 330, a legal private contract is now in force. The bank no longer recognizes Dorothy's estate as having any claim to the funds. It recognizes Michael and Sarah as the sole absolute owners of the money. The teller prints 2 cashier's checks for $175,000 each. The fee for this transaction is $0. The probate court receives nothing. The attorney takes nothing. The Daily Herald prints no notice. The wait drops from 14 months to 48 hours. Michael and Sarah walk out of the bank, pay the funeral director in cash, and go home to mourn their mother without a courtroom hanging over their heads. That is the entire difference. One form, 7 minutes, no cost. The legal concept behind it dates to a 1904 New York court decision called the Matter of Taunton, in which the court established that a person could hold money in trust for another. Banks call this a Taunton trust, a transfer-on-death account, or a payable-on-death account. It is one of the most powerful legal instruments available to ordinary Americans, and most people have never heard of it. I need to address something directly, because this is where a lot of people get confident when they should not be. Many people watching this video have a living trust. A living trust is a legitimate and often excellent legal tool, but a living trust only controls assets that have been formally transferred into the trust. If you open a bank account after establishing the trust, or if you never retitled the account in the trust's name, the account still falls outside the trust entirely. The same probate trap closes around it. An unfunded trust is a legal document that solves nothing. The payable-on-death designation accomplishes the same bypass the trust is designed to create, and it does it for free at the branch in minutes. The same logic applies to joint tenancy. Many seniors add an adult child directly to a bank account as a joint owner, thinking this solves the access problem. It does solve the access problem. It creates 3 new problems that are potentially far worse. When you add a child's name to your account as a joint owner, the law treats that money as partly their asset while you are both alive. If your child is in a serious car accident and someone wins a judgment against them, the plaintiff can levy your bank account. If your child goes through a divorce, their spouse can claim a portion of your savings in the settlement. If your child falls behind on federal taxes, the IRS can seize the funds to satisfy their debt. Every one of those scenarios is perfectly legal and happens regularly. The payable-on-death designation avoids every single one. While you are alive, your child has no ownership interest whatsoever. The transfer only occurs the instant you die, and only if you have not already changed the form. Your money is protected from their creditors for your entire lifetime. There is one more trap worth understanding, because it catches people who think they have already protected themselves. The safe deposit box. Most seniors store the physical will, the house deed, birth certificates, and irreplaceable documents inside a metal box at the same branch where they bank. They hand a spare key to their oldest child. They believe the key grants access. The key grants nothing. When a bank learns of your death, federal regulations require them to seal the safe deposit box immediately. Your child can stand at the counter holding the key, and the bank manager will turn them away. To open a sealed safe deposit box, your family must petition the probate court for a specific court order authorizing access. Here is the circular nightmare that creates. You need the will to open the probate case. The will is locked inside the box. You need a probate order to open the box. You need the will to get the probate order. Families pay attorneys hundreds of dollars just to untangle this loop before the real work even begins. The solution is simple. Go into the branch and add your child as a joint renter on the safe deposit box contract. It costs nothing. It requires both of you to sign a form. It means your child can walk into the branch the day after you die and access every document inside without involving a single judge. The system survives on inertia. It survives because people do what Dorothy did. They work hard, they save carefully, they hire an attorney, they sign a will, and they believe the problem is solved. The banking system is counting on that assumption. State probate courts are funded in part by the fees generated from estates exactly like Dorothy's. The attorneys who handle probate work are not villains, but they are not motivated to tell you that a free one-page form makes their services unnecessary. You are sitting somewhere right now, and there's a reasonable chance you have a bank account with nothing but your own name on it. There's a reasonable chance your family would walk into that branch next week and be handed the same polite refusal Michael received. The gap between Dorothy's outcome and the better version of that story is 7 minutes and a piece of paper that costs absolutely nothing. Go to the branch this week. Ask for the Payable-on-Death beneficiary designation form at the teller window, not the drive-through. Bring the full legal name, the date of birth, and the social security number for every person you want to receive your money. Name a primary beneficiary and at least one contingent beneficiary, because if your primary beneficiary dies before you and you have not updated the form, the account reverts to your estate and falls directly back into the probate trap. After you file the form, ask the teller to print your current beneficiary designations every time you visit the branch. Set a reminder to review the form every 3 years, or anytime someone on it gets divorced, remarried, or dies. This is not a complex legal strategy. It does not require an attorney. It does not require a trust document. It requires one trip to the branch and 7 minutes of your afternoon. Dorothy had $350,000 in a will and an attorney and a fireproof box. None of it protected her family. A form she never filled out would have protected them completely. Take care of your family while you still hold the pen. Next week, we are going to look at the Medicaid look-back period and the specific asset protection structure the state cannot pierce once it is in place. Leave your state in the comments below, and I will make sure we cover the rules where you live. If this is the first time you have found this channel, subscribe now, because everything we discuss here is the information that the institutions hope you never find. This material is presented for educational purposes only and does not constitute legal or financial advice. Consult a qualified attorney regarding your specific circumstances.